Judges are going to start roaming free. There'll be like a third house of Congress, or there'll be a ombudsman for the executive branch. And he said, in fact, they will run the executive branch because every executive branch decision, every law of Congress will be appealed to the judges, and some judge somewhere will say, I'm going to run this policy. And so I think Scalia's prescient warnings about that have come to fruition now. What the Supreme Court can do is remind these lower court judges, you only have the power to decide the case or controversy. Let the Supreme Court worry about harmonizing everything nationwide when all the different cases get back to us.
This is CBS Eye on the World. I'm John Batchelor. I welcome Professor John Yoo, the Civitas Institute of the University of Texas and Berkeley Law School. However, I'm going to call upon John. In his youth, he served the George W. Bush administration. And in his youth, he takes us on a stroll down memory lane in a recent article about challenges to the United States' understanding of due process and the courts made by men who insist upon being violent, a threat to the United States, and may or may not be out of place. For example, terrorism. Also, for example, gangland activity or coming into the United States without documents. All of that comes to recent current events. One, the deportation of so-called Trinidad terrorists by the ICE service and the United States government, Mr. Trump's administration, to El Salvador, where they're jailed. And their fate is determined by a man, Bukele Naib, who is a president of another country, not our country. And the other is a man from Maryland named Abrego, who everybody acknowledges now was incorrectly detained and transported also to El Salvador. These questions all bring up what is to be done. And John Yoo has published a piece recalling how the Bush administration early on had to deal with these cases. John, a very good evening to you. The Alien Enemies Act, that is what is cited, late 18th century, by the Trump administration. But your challenge was to deal with what is a war and what is not a war. What is the important distinction between declaring a war and getting Congress to agree and not declaring a war and using warlike powers? Good evening to you, Professor.
Good evening, John, and thank you very much for having me back, and happy birthday to you and the State of Israel.
Thank you.
Two very important events 77 years ago. I thought what I would do in this piece in City Journal is recall how when I was a young official in the Justice Department, faced with the aftermath of the 9/11 attacks, how we had to think through some of the same problems that confront the Trump administration. As you said, John, one of the very important things, the fundamental thing, was, were we at war? In that case, back in 9/11, administrations of both parties had treated terrorism as a crime, as something that happened in peacetime. The reason why war is important is because once you're at war, you can detain members of the enemy. You can hold them. You don't have to put them on trial. You can just hold them until the war is over. Under the Alien Enemies Act, if you're fighting against a foreign government, you can detain any national of that government in your country. You don't have to put them on trial. You can hold them, or you can deport them. And I thought what I'd do in the piece is contrast that with President Trump and his immigration agenda, where we have treated immigration always as a civilian matter, as a peacetime matter. But what Trump is doing, in a way, is kind of retracing the steps we took towards the war on terrorism after 9/11. Trump, in invoking the Alien Enemies Act to deport these suspected Tren de Aragua members from Venezuela and send them to El Salvador, he's trying to alter the legal system, the political system towards immigration, to have some of the features of war. But there's important differences, as you pointed out, John, in your first question, is after 9/11, although we thought constitutionally the president could respond immediately, we thought it important to go to Congress and get what they called an authorization to use military force, which is tantamount to a declaration of war very much for the questions we're talking about now. Would people be able to be held? What kind of due process would they get? What would be the role of the courts? That's a glaring difference from what's going on now with President Trump. He has sought no congressional approval for his efforts to claim we're at war with Venezuela and that the Tren de la Aragua is some kind of arm of the Venezuelan government. And so we can detain Venezuelans and kick them out of the country without any kind of criminal trial or anything like the process we usually have in federal courts.
The Supreme Court weighed in on this for the Bush administration, and it's important to touch upon these decisions because the court provided guidance, except for there was some bumps in the guidance. Hamdi versus Rumsfeld is the famous case, but we're dealing with, and John, this reads like a stroll down memory lane. We were both younger then.
Yes.
John Walker Lindh, the American Taliban, who spent nearly 20 years in jail and is now released. He was released in 19 and went into supervision for 3 years. And Richard Reed, that's the famous shoe bomber who meant to murder people on a flight into Detroit. Jose Padilla. All of those men were regarded as terrorists and a threat to the United States, except the Supreme Court wanted them to have due process. Is that correct, Professor?
Yes. In the end, the rule became, and we accepted that in the Bush administration, the rule became, first, any American citizen, so like John Walker Lindh, you might remember, was captured in Afghanistan fighting for the Taliban, right? He joined the Taliban before 9/11, right? He joined al-Qaeda before the 9/11 attacks, and we found him in Afghanistan. First, we said any American citizen worldwide will be brought home to the United States, and we'll choose to try them under the criminal laws or we'll hold them. Both Lindh and Jose Padilla are American citizens. Unfortunately, both were affiliated with al-Qaeda. Remember, Jose Padilla tried to get back in the U.S. and try to blow up some kind of dirty bomb, right? Some kind of bomb with radioactive material attached to it. We chose not to try Jose Padilla. We chose to try John Walker Lindh. Then we had people in the U.S. who were not citizens, who were aliens. But we thought the rule was that the Supreme Court from the World War II cases said people in the U.S. get due process of some kind, whether they're aliens or citizens. So you might remember we captured a fellow named Zacharias Moussaoui, who was the 20th hijacker. I don't know if you remember this. And we decided to give him due process. He eventually pled guilty. The question that the Supreme Court, and you remember Mr. Hamdi, he was an American, well, no, I'm sorry. There's so many of them. But Hamdi is someone who's also captured by the United States. We decide to give him due process. The question is, what happens with the people outside the U.S., people who are not American citizens or have no connection with us? We thought the rule was they're just held as prisoners of war would be held, as enemy combatants would be held. There'll be some kind of process, but it will be a process provided in wartime that the military usually engages with. And so all those cases, you remind me, John, as you said, this is like a walk down memory lane. They culminate in cases about what is Guantanamo Bay? Is Guantanamo Bay inside the U.S. or is Guantanamo Bay outside the U.S.? But in general, putting aside Guantanamo Bay, which is a hard case on the margins, the general framework is people in the U.S., we find them in our territory, we give them due process. People we capture in Afghanistan, people we capture in Iraq, they don't have the benefit of due process in our civilian courts. They're captured, held by the military. The military provides them with process, but it's not the same kind that we give in the United States.
Do I remember correctly, John, these matters, that there was a debate the whole time, a lot of tension with Congress, a lot of finger pointing going on. And when the Supreme Court weighed in and said due process is necessary, that stopped the finger pointing and the blame shifting. And due process did not in any fashion dislodge the intention to contain these men as threats. It took a little longer, but in the end it came out right. Do I remember that correctly?
Yeah, I think you're right, John. There were a lot of, as you put it, there were a lot of bumps in the road because we were dealing with, and part of that, I think a lot of that is because of the unprecedented nature of the attacks, which have some similarity with what the Trump administration thinks Venezuela is up to. We're fighting an enemy, al-Qaeda, that wasn't fighting in uniform. It wasn't like the German army in World War II or the Japanese army. They weren't fighting in regular groups, regular units with uniforms, defending territory, defending a city. They were deliberately camouflaging themselves as civilians to infiltrate into our country and launch massive attacks on our civilians. All violations of the rules of war, by the way. So Hamdi was a very important case because there were a significant number of people in Congress, a lot of professors, a lot of leading figures in the bar who thought we could not have a war, that just there was no such thing as a war against a terrorist group. You could only have a war against Germany. You could only have a war against Japan. And in Hamdi, the court said, because Congress and the president agree that we're at war, we will not second guess this. We accept their decision. And so someone like Hamdi, who happens to have been born in the U.S. as a child, but goes back to the Middle East and is caught fighting for the enemy, we'll give him some kind of due process because he's a citizen. It doesn't necessarily have to look like a criminal trial. But the key thing was that the court said war can take these irregular forms. It's not just a crime. The government and the United States are not hamstrung by this either or, war against nations, crime against groups. And so that was an extremely important case. And again, as you also say, this principle, I think that the Bush administration agreed with, that we're going to have due process for everyone in the United States of some kind. I think you're right, John. I think it did stabilize the rules and that a lot of the fighting about the war on terrorism subsided because it gave people confidence in how the executive branch and the courts were going to treat people, that there weren't going to be people who were caught by mistake. I think that's very important for the American people to understand. The government, the Bush administration doesn't want to hold anybody by mistake. We don't want to hold anyone who's not a member of al-Qaeda. That's a waste of resources and time for everybody and a deprivation of civil liberties. So the court and the Congress and the president all agreeing on that. I agree with you, John. I think a lot of the controversy in the war on terrorism started to subside because we had a system. But it took a few years for that system to really emerge and be agreed on.
You have a checklist in your article. We've touched on all of them. Make sure it's understood as an act of war. That is critical. Due process is needed and answers a lot of questions that otherwise could be asked. And this one, John, this is the tough one. Obey the Supreme Court. That was then. Is that now, John?
That's the hard question is this president going to obey the Supreme Court? Now, the Bush administration could have gone farther. They could have gone as far as the Trump administration. As we've discussed before on your program, the only president who's really done this before is Lincoln at the start of the Civil War, where the courts opposed him, where Chief Justice Roger Taney, the author of Dred Scott, ordered Lincoln to release Confederate prisoners because they said, this is not a war. This Civil War is not a war. There's nothing in the Constitution about a civil war. This is just people you've picked up because you think they're criminals. They should get criminal trial. Every Confederate prisoner should get a criminal trial with a jury. And Lincoln just said, you can't fight a war that way. We can't fight the Confederacy if we're treating every single one of them as a criminal defendant. So in the Bush administration, we decided early on we could not follow the Lincoln precedent because we needed to have a set of rules in which the American people would be confident that it would harm the war effort to have the presidency and the judiciary at odds. So I think that's very important, John, because you said this time, though, now President Trump has said on TV that he will never defy judicial order. But you have people in his orbit and his universe attacking judges, saying we should impeach judges, suggesting that if a judge ordered the actual release of any of these Tren de l'Aragua suspects, that they might think about declining to obey the order. I think that gets you into very dangerous territory. And instability, political and legal instability, I think detracts from any kind of either war effort as it was 20 years ago, almost 25 years ago, or pursuing a tough immigration agenda today.
John, what is the nature of the argument that the Supreme Court must choose between can the Trump administration shove aside, elbow aside, or in otherwise block a federal judge who stops the effort of the whole government on the basis of, I think they call it a temporary stop?
This is the question of what is sometimes called nationwide or universal injunctions, where a single federal judge anywhere in the country, and there are 1,000 federal trial judges in the United States, any single one of them says, I think President Trump's executive order on birthright citizenship is illegal, or I think President Trump's refusal to spend money, right, to sequester it, is illegal. And so I order the entire government to stop in its tracks, not just with regard to the people who are in front of me in my courtroom who have sued, but with regard to anybody, right? So that's why they call it nationwide or universal injunctions on the government. I tend to think, and several justices of the Supreme Court think, that that is an unconstitutional use of the power of a judge. The judge can only decide the case before them with the people in the courtroom in front of him or her. They don't have a power to tell the government what to do nationwide with regard to everybody. That is what's really behind the fight that Trump is having with all these judges. Trump has, tried to break FDR's record in the first 100 days. I think he just did in number of executive orders filed. I think he's also now broken the record for number of injunctions by judges against his executive orders because of this decentralized federal judges all over the country, all, here, there, blocking his government as a whole from acting. So the Supreme Court has announced, this is remarkable. Usually the Supreme Court by now is done hearing cases, and now they're just writing the opinions, issuing the opinions, getting ready for summer vacation. But they've ordered a special session of the court for May 15th to hear the arguments about not just really, there are 4 judges who've blocked birthright citizenship throughout the nation. But what they're really going to hear is, can these judges do this? Can they stop the government in its tracks nationwide? Or are they only limited to deciding the case that's right in front of them? This gives Roberts, actually, Chief Justice Roberts of the Supreme Court, a way to diffuse this huge conflict that we've been watching between the courts and the presidency.
The Article 3 of the Constitution you cite in your New York Post piece talks about cases and controversies. How is that interpreted, John?
So this is a big fight. That is the crucial text, John, at the heart of this case, because cases or controversies, I think, means the dispute before the judge, right? Who is suing? So if take, for example, the cases we're just talking about. Suppose you are 6 of the Venezuelans who were deported to El Salvador.
Right.
That is the case that's before the judge, is a case brought by those 6 Venezuelans.
Just the 6, not
just the 6. Yes, exactly, John. Just the 6. So if this judge thinks that you can't be deported to Venezuela under the Alien Enemies Act, then I would say only those 6 benefit from that judge's decision. But the judge doesn't have the power to then say, and bring back all the other 300 who are sent, who I don't even have in front of my courtroom. Justice Scalia wrote a very interesting opinion where he said, if you expand this case or controversy requirement, judges are going to start roaming free, and they'll become like the third branch they'll be like a third house of Congress, or they'll be a ombudsman for the executive branch. And he said, in fact, they will run the executive branch because every executive branch decision, every law of Congress will be appealed to the judges, and some judge somewhere will say, I'm going to run this policy, not the executive branch. And so I think Scalia's prescient warnings about that have come to fruition now. And so I think what the Supreme Court can do is remind these lower court judges, you only have the power to decide the case or controversy. Let the Supreme Court worry about harmonizing everything nationwide when all the different cases get back to us through the regular appeals process. But district judges don't go about thinking you have, as you said, John, when you start, the power of God to run the government. That's not your role under the Constitution. We have much more limited role for courts.
John Yoo is a distinguished visiting scholar at the School of Civic Leadership, University of Texas at Austin, the Civitas Institute. He's also the Emanuel S. Heller Professor of Law, University of California at Berkeley. This is CBS Eye on the World. I'm John Batchelor.